bicameral, bipartisan set of legislation that we passed. Senator Lee.
He is indeed famous, and I'm glad to have him here. He's so famous that he's infamous, but he told me that that's not really the term that he likes to use. So,
Senator, I just want to let you know I caught that reference to the Three Amigos.
thank you. I'm so glad you got that. Extra points for you, Mr. Cantor. Chairwoman Khan, let's just start with you. I'm hoping you can explain something to me. In the FTC's monopolization case against Facebook for its acquisition of Instagram and WhatsApp, the FTC relies on a personal social networking market definition. That's where they're going with that definition. And the FTC explains in its complaint that, quote, other types of internet-based services available in the United States that facilitate the sharing or consumption of content are not adequate substitutes for personal social networking services. In other words, seems to be saying, even though other services have incidental overlapping with Facebook, that doesn't mean that they're in the same market. And yet, in the FTC's complaint to stop Meta's proposed acquisition of Within, and remember, of course, Meta is just, the new name for the mothership at Facebook, that complaint relies in part on what they refer to as a, quote, VR fitness apps market definition. And the complaint states, quote, the broader market includes both VR dedicated fitness apps and incidental fitness apps, close quote. So here, the FTC seems to be saying that products with incidental overlapping uses are, in fact, competitors. Now, are these two market definition theories compatible? Because it seems to me that they are quite wildly inconsistent and indeed mutually exclusive. And I'm worried that the FTC putting forth these contradictory legal theories within a very short period of time, and these suits were filed within a year or two of each other, is something that could weaken FTC's ability to fight against big tech, and that concerns me.
Thanks for the question, Senator. As you know, our challenge of Meta's acquisition of Within is currently pending in our administrative proceeding, so I don't want to say anything that could risk prejudging that. I'll just say generally on market definition, these are very fact-specific inquiries, and I think our staff on both sides did a rigorous job in putting these forward.
Okay. Are you disagreeing with my characterization? I understand here the market definition is everything. Market definition matters. And the market definition might be differently assessed in one industry than in another. And it's hard for me to look at this and conclude that these are anything other than the same market forces at play. Do you disagree with my assertion that they are wildly inconsistent market definitions?
Again, Senator, I really would hate to prejudge anything while this.
I'm not asking you to prejudge it. You are the plaintiff in these cases. You're the enforcement agency. These are your allegations. I'm not asking you to prejudge. I'm asking you to describe your own agency's differing use of wildly inconsistent standards.
Once the commission votes to file a Part 3 action, as we did in Meta Within, there's a wall that goes up between the commission and the staff. So it's the complaint counsel, the staff that are the plaintiff, no longer the commission.
Okay.
And I'm happy to check in with our staff and see what we might be able to share with you on a non-public basis. But again, we're very mindful of that wall and take care not to.
I understand that. I understand the distinction you're talking about. But again, we're not talking about prejudging here. I'm not asking you to prejudge the outcome of the case. I'm simply saying that the allegations raised in your complaint filed by your agency take two different approaches in essentially the exact same industry. It's hard for me to grasp that, but I understand you're not going to answer it, and that's frustrating and disappointing to me. Mr. Cantor, let's go to you. Imagine a court ruling. Imagine might not be too difficult, but a court ruling holding that a social media company with market power may be deemed a common carrier and therefore could, consistent with the Constitution, be prohibited from engaging in censorship. Would that, or in what way would such a court ruling affect your assessment of whether such a firm is a monopolist?
Thank you, Senator. I would certainly want to make clear that it would be important to assess the specific facts and circumstances before reaching any conclusions. But to extend a court concludes that a firm is a common carrier, then that's certainly an indication of monopoly power, and the antitrust laws should apply accordingly.
Okay, so it may be an indication of that. You're not necessarily saying it would be conclusive, but it might be an indication of that.
Well, if it's a common carrier,
It's a common carrier.
it's likely to be
Yes.
pretty close to conclusive.
Right. In fact, it would be very difficult to get around that once you reach that conclusion that it's a common carrier, wouldn't it?
Well, I again want to reserve judgment on any specific set of facts, but as a general matter, yes.
What sort of thing could get one out of that conclusion once you had reached the conclusion as to common carrier status?
Sorry, Senator, I'm not sure I'm following the question.
If it's not conclusive, what would make it non-conclusive?
It really depends on the facts. One of the things I've learned in my practice, as I'm sure you appreciate from yours, is that every fact pattern presents differently, and you often see things that you don't expect or don't anticipate. And I think one of the most important things we do in our job is to make sure that we are assessing each set of facts before us. So I'm happy to answer generally, as I did, and directionally, but I do want to be very careful not to exclude a wide range of possibilities, some of which I might not be able to anticipate.
Understood. Looks like I'm out of time for this round. Thanks.
All right.
Madam Chair.
Oh, very good, Senator Lee. Thank you. Next up, Senator Blumenthal, then Senator Grassley, and then Senator Whitehouse.
Thanks, Madam Chair, and thank you for having this very important hearing. Thank you both for being here and for your very good work.